All right, everybody, I'm going to try to go through the constitutional violations packet with you really quick, as fast as I can. Just not enough time in class for me to really be able to go through everything with us starting the next topic. And so I want to have this as a resource so you can come in here, you can check and see what you had. If you had a different take on one of these and you want to talk about it in class, then we may be able to carve out a little bit of time later on to specifically talk about those. But so here we go. For case number one, this is the one about the students who had published the information. This is a First Amendment issue as far as questioning freedom of speech. Since this was a threat and since this was dealing with the students at this school, this would fall under the Bethel School versus Frazier case. And so these threats would be considered extreme, especially since they're talking about murdering and even raping the teacher. So the students would not be protected in this. For case number two, you have a lot of disruptive events at the school. This does relate to Tinker versus Des Moines, with the students who had the armbands on. The school could not tell one group of students that they could wear something, but another group of students that they could. So you had to distinguish that in some way. This is a First Amendment related court case because it's freedom of speech, and your clothing is an extension of your speech. So the school does have the right to tell certain students overall that you cannot wear any of these types of clothes because it causes a classroom disturbance. That is okay. For case number three, Marvin Pickering had published in a newspaper some information about the school. This is also protected by the First Amendment with freedom of the press. This was not in a school newspaper. This is just the community newspaper. You are protected. This relates to Busink versus Woodlawn, where the student had made the website that was critical of the school. So you're protected in that matter. Now, if you said something about slander or libel, if the student was making allegations that were just completely outlandish, and it was proven, the principal or the superintendent could file his own lawsuit, but the student was protected if he had concerns about what was going on at the school. For case number four, about the chess club, this would also go in. You could have taken the approach of equal access. You could have made a stretch, maybe with Brown versus Board of Education, even though that was about race. You could say the school can't pick and choose. It can't disallow one group of students to meet but allow another students. But really what would probably be better would be New Jersey or Tinker versus Des Moines. Even though that was with clothes, it was with an opinion, which is protected by freedom of speech. If the school lets one club meet but not another club meet, the school can get in trouble for that. So the school would have to allow all the clubs to meet or none of the clubs to meet. And that would have been the decision on that, again related with the First Amendment. For case number five, you got a group of students who are rolling up the right pants leg. This relates again to Tinker versus Des Moines, a First Amendment freedom of speech / expression with clothes. But the school is protected because the police officer says that this is a gang-related expression, so the school can regulate that. With case number six, the graduation committee asked has a rabbi come and deliver the invocation, which is the prayer. This relates to Engel versus Vitale with the First Amendment. With Engel versus Vitale, though, the key was that was a school personnel that was leading the prayer. In this situation, this is a volunteer, so as long as the school would allow anybody else who wanted to lead an invocation or a prayer and would allow students to not participate, the school would be safe in doing that. With case number seven, this teacher is taking out students to pray, and this teacher is actually leading the other students in this prayer. This would be a violation of Engel versus Vitale again. This relates to the First Amendment, freedom of religion. However, this would be a violation because the teacher is the one that's leading the prayer. So the whole thing about being able to be let out of class multiple times, that was not even relevant. It's the fact that the teacher is leading the prayer. For case number eight, the student is taken, the administrator searches the student's locker. Everything's completely fine right there. The principal can act off of reasonable suspicion after New Jersey versus TLO. But the problem is, after it says, meanwhile, the school resource officer is searching the student's car while the administrator is inside the building. That is a violation. The school administrator has to be with the school resource officer when that search is going on because the officer only has probable cause, and the officer can't do a search on school property without the school administrator or without a warrant. So this is related to New Jersey versus TLO. Let me back up a little bit. The cases that were about religion, you can make a connection with West Virginia versus Barnett. Forgot to throw that in there. as well as Engel versus Vitale. That would actually be the best precedent for those cases. For case number 9, you have a student who has been drug tested, I should say, at school, and the random drug testing is a violation of the Fourth Amendment, just as the case previous is also a violation of the Fourth Amendment. The reason that case number 9 is a violation, it relates to the Board of Education versus Earls. And with this case, the Supreme Court decided that students cannot be subjected to random drug tests at school. Parents first have to give permission, and so that's why if you play a sport, you get those permission forms signed. All right, as far as Section 2, qualifications for a Supreme Court justice. There's 0 qualifications, also 0 term limit, or a maximum term limit is life. So the reason that it is this way, the Founding Fathers wanted to make sure that Supreme Court justices showed impartiality. So if they were making decisions that were supposed to be solely based off of the Constitution, if the Supreme Court justices had to worry about running for re-election, that could possibly influence their decisions in ruling on certain cases and exercising judicial review. They wanted to make sure that it wasn't politically motivated. So that's why they stay completely above term limits and also beyond qualifications. They didn't want to have anything holding them back from making those decisions. For Section 3, for the constitutional violations, Violation A, about the president declaring a food emergency, only Congress can do that, and that's in Article 1, Section 8, as far as the powers of Congress. For Violation B, Congress controlled both houses by Democrats, and then they passed a bill to make Republican Party illegal. That violates the First Amendment freedom of speech. Your political beliefs are an extension of your freedom of speech. That cannot be taken away. That's why in the United States today we have other extreme parties like the American Nazi Party, Communist Party. Those are all completely protected by freedom of speech in the First Amendment. For Violation C, says that Congress will recess and not permit to meet again for the next 18 months. Constitutional Article 1, Section 4 says that Congress has to meet at least once a year. Violation D, Congress passes a bill naming 15 students guilty. Congress cannot pass a bill of attainder. In Article 1, Section 9, it says that is unconstitutional. So Congress can't do that. That would also violate your Fifth Amendment due process. Congress can't just automatically say that someone's guilty without a trial. Violation E, Congress orders an aircraft carrier to the Persian Gulf. Only the president can send out the troops because of Article 2, Section 2. Congress can declare war in Article 1, Section 8, but they can't send out the troops. With Section 4, the chief responsibility of the judicial branch would be to review the constitutionality of law, so that's C. For 2, how many justices are on the Supreme Court? There are 9, so that's C. The title of the person holding the top post in the judicial branch will be the Chief Justice. The responsibility of the judicial branch of the government is to apply and interpret the laws. The responsibility of the judicial branch is outlined in Article 3 of the Constitution. Supreme Court justices are nominated by the President and then confirmed by the Senate. The power of the Supreme Court to review any law is called judicial review. The only Chief Justice of the Supreme Court to also been a president would be Taft, the bathtub guy. The Supreme Court justices are appointed to serve for life. The trial court has original jurisdiction. That's where the cases would start. This is the court of last resort in all questions of federal law, so it can't go any higher than the Supreme Court. The Court of Appeals has appellate, or some people say appellate, jurisdiction. The state may not take a person's life, liberty, or property without due process, which is a court case. The majority of cases in the Supreme Court here, they come from lower courts as appeals. Justices reach the court through presidential appointment, and then finally the president's most important influence over the court is the fact that they appoint the justices, and then they have Senate's consent. Okay, so this was really fast. If you want to talk about any of these items, if you want to give me your plea and explain to me what your rationale was, then we can definitely have a great conversation about that. Otherwise, I will talk to you guys later.